Good morning, everyone.
Good morning.
Good morning.
Oh, Lord. The first two sound like they're sleeping. Wake up, wake up.
I'm up.
You're up?
Yes, ma'am.
Okay, all right. There's some more people coming in. Okay. So you are now on the last assignment, correct?
Yes, that's correct.
Can I assume that you have drafts ready?
Partial draft.
Okay, partial drafts. Okay. At least this last assignment is not that difficult. Any questions before we start units 15 and 16?
Not yet.
Not yet.
No, ma'am.
Okay. Because how we have the schedule, we'll do 15 and 16. And next week, Saturday, we'll look at the assignment questions. And then the last class, we'll do 17 and 18. So that's why I asked. So next week when you come, hopefully during the week, you would send me your first attempt on the questions.
Okay.
You actually have about a month to answer it. So that's why I asked if you have any questions at all.
Okay.
So I wouldn't want to wait until next week to explain what the questions are about. I prefer to do that today and then leave you to send your draft to me through the week. So next Saturday we can go through the draft and point out where there's inconsistencies or where you're just not answering the question.
Okay.
All right. So turn to the question. And someone tell me what A is all about. What is it that examiner is looking for in A? Anybody, those who have tried it already, or those who are going to try it later today, to start to draft an answer. What is A all about? Any ideas?
Hi, good morning.
Go ahead, morning.
Hi. I had some connection issues earlier, but I'm trying to catch up. You're talking about the assignment 3 question A, right?
Yes.
Okay, so basically it's talking about like beneficial ownership and the importance of like establishing who the beneficial owners of corporations are and stuff. And yeah, and just the issues that come with not substantiating or obtaining who the true beneficial ownership of companies and shell companies and all of that stuff is. going on about.
Okay. So that's the general gist of it. So, but what now? I need someone to tell me what is the question asking you now. You're correct. That's what the question is about. But what does the examiner want? What do they want from you?
Well, specifically as it relates to the jurisdiction that we would choose. So in our case, the Bahamas, the issues, I guess, that would usually arise when you're trying to determine who the ultimate beneficial owner is.
Mm. Okay. Let me word it for you another way. The
Mhm.
first thing they ask you to do is to evaluate the extent of the issue. What is the issue? Based upon what they wrote, the 2 paragraphs above, what is the issue the examiner wants you to concentrate on?
Money laundering by concealing beneficial ownership,
Yes. But
especially with
more.
especially with board structures and like, oh, I'm trying to remember the name of the companies that I was looking into, the shell companies and stuff. Hold on a second.
Come on, this is a big class. I know you would have started to think about the answers. You may have drafted something, but I don't want you to send me your draft and then you haven't answered the question because you would have wasted a lot of time. I want to be sure that you understand what the examiner is looking for. So you started it.
Yeah, and then I had another note. I'm trying to get myself together. I have I don't know how relevant it is, but the question of business growth incentives versus security, like, and where you would place where we place the priority, because like the question, how I was looking, I was reading, it was like how these are stuff that are supposed to be used for like growing industries and growing firms, right? But at the same time, they could also prevent a security risk by people misusing them. So like, I was also thinking that you have to like also touch on the balance there between the two, between businesses being, we want to get business, but at the same time, we have to be ensure that it's done correctly and securely.
Mm-hmm. That's the point. You can mention it, but don't elaborate on it. That's not what they're looking for. I understand where you're going with that. In terms of from the Bahamas perspective, this is how the tools that we have implemented were designed to encourage business growth internationally and develop a business and we develop a sector. Because the nominee services are the FCSPs. And of course, the limited companies are the IBCs. And that is a market that we've been in that has grown over time. But what exactly is the examiner? What is the examiner's issue? Because he wants you to evaluate the issue. So you have to determine what is this issue that he wants you to evaluate.
Okay, I was looking at it from a point where the benefits of the LLC and the NDS, those benefits are what criminals use to their benefit. Because with the LLCs and the NDS, they protect the criminals. They hide them. They use them to hide under them. So, and because they use them, it creates like a layering, and it becomes very, very difficult to find out who the beneficial owner is. So with our laws in place, do we have the laws in place that Part F require us to have in place to minimize criminals from using LLCs and NDS for terrorism financing and money laundering?
Okay. So if I hold on now, if I go on the point that you're saying, how do you know they are criminals?
We really don't know because the company seems legit. It seems transparent because we can see the company, but is it really transparent? So we have, because we don't know, and when we suspect, when law enforcement and when they suspect, their job becomes very, very, very complicated to prove. Because like it said, it's hidden in plain sight. Here we see a business going on, and but how do we get to the bottom to know that they're not really criminals? The company is not being used for illicit purposes, and the challenges is because of the different jurisdictions and the different laws. It just makes it very difficult. So I think they're saying in our jurisdiction, how do we evaluate? How do we find out? Evaluate the issues. I was reading where Maria, one of our classmates, she sent an article by the Attorney General when he addressed it just recently, and he was saying that we can now amend the laws to have the Ministry of Finance involved and just not law enforcement agency because of the public registry, things like that. It's very difficult because we are what you call another tax haven, and it's just difficult. So what measures do we put in place? Because yes, they are using it, and then how do we prove it? And that's what I'm getting. I think I'm going in that sort of direction.
Okay, so I see you're focusing on the measures, which is the last part. The difficulty associated with tracking ultimate beneficial owners, you have to discuss that. But more importantly, I need a class to focus on what is the extent of the issue. What is it that they're asking you for? Because that's the source of what you're going to build this answer on for 50 points. An examiner is not looking for you to give him back what is in the report on the concealment of beneficial ownership. That's not what they're looking for.
Boy, and I sure did use that when I used New Zealand case study 77, and I was going by the points and ripping it, trying to analyze each point. Because I was thinking, like, in that particular case, that has a lot of layering, and no name, absolutely no name is mentioned No beneficial owner is
Right.
mentioned in the case. So that's where I was going. So now I going in the wrong direction.
Yeah, let me see, anybody else?
Hi, good morning, Miss Archer. Can you hear me?
Yes, I can.
Hi. I think what I probably need to do to answer this question is to find out exactly how companies are set up. And I don't know if anybody else in the class has a clear idea of the different kinds of companies and how each of them are set up. And I think that's where I need to start in order to answer this question.
Okay, so
We do have a,
let's stop right there for you.
okay.
We'll stop right there. Who in the class could explain to her these companies? Because this is the whole point of this class. If you were actually in the classroom, it's a point where you put all your ideas together and people speak about their experiences and then what they know from knowledge and firsthand experience. So this isn't just reading the book. This course is practical. And when the examiner is reading your answers, he's looking to see not only that you know the law, you know the theory behind it, but he wants to see how do you apply it. And your paper have to give him the sense that you actually know what you're talking about. It's not a regurgitation of what's in either one of the typologies, or it's a regurgitation of something you saw on the internet, or you regurgitating the actual law. What sets a student apart from another student is how well you're able to interpret what's in the manual to everyday life. So for those who don't have that experience in AML, it is always good for their colleagues in the group to share what they experience in their day-to-day life in AML. Is by sharing is how you will learn. So someone explained to her a company, how it is formed in simple terms, because she only needs to grasp the concept. Anybody? Nobody? Okay, so when you read the question, it speaks about these vehicles being used. And the vehicles used in the Bahamas is either a company that is established under the Companies Act or a company that is established under the International Business Companies Act. This question is referring to companies that are established under the International Business Companies Act. And in the Bahamas, that has been a vehicle that we have used to attract foreigners who want to do business internationally. So what they do is they contact a financial corporate service provider, or they contact their lawyer and they say, I want a company. And the law firm or the FCSB will incorporate a company, and the incorporation of the company and the structure of the company, that means the structure means the ownership of it depends on what the customer is looking for. Now, the whole purpose when IBCs came out as international business companies, when that came out, that actually was designed to give clients anonymity. Clients didn't want their names all over the world. And so that's why they would go ahead and incorporate a company. Once you incorporate a company is a separate legal entity. It has its own personality. So the shareholder was the owner of the company, and it may not be, ultimately it will be an individual at the very top. But when you look at the structure, you will see different types of vehicles being used. Now, over the years, the international community, the G10, the G20, the G7 have decided that these structures are a hindrance to them finding out who is the ultimate beneficial owner, the individual at the very top. And that is a concern to them, is because they need to tax these persons. So within any structure, for someone who is who's doing business overseas, they may have a holding company at the very top. That is another company that is established just to hold shares or hold assets. And then they can have an IBC below it. In between the holding company and the IBC, they can have an executive entity. And that person would act as if it's a human, providing directorship. Some law firms and trust companies and FCSPs, financial corporate service providers, offer nominee services. A nominee services means that there is no way on the documents you have the name of the actual ultimate beneficial human person. What that company does is it offers a service to the client by saying, we have a company that will hold the shares of this company for you. So your name is not on the register at all, but our company is on the register. And this is what they're talking about. This is an issue because when they find that there's an actual company that is involved in money laundering, and then you ask for the documentation behind it, who owns this company? Who are the directors on this company? You cannot find the name of the ultimate beneficial owner. All you will see is names of companies. And they're saying that when there is a money laundering issue and the police have done their investigations and now they're going before the courts, they tell you in the third line that it is a challenge for prosecutors and for the police and the financial crime unit and for the FIU to actually bring a case to closure because they do not know who's the ultimate beneficial owner. It's not recorded in the registry. So the question they're asking you, the very first one is, they want you to evaluate the extent of this issue. How wide is this issue? Is there really an issue? How many cases are being brought before the courts, and the courts have not been able to actually give a ruling to it because they do not know who's the ultimate beneficial owners? That's the issue they want you to discuss. It's not a repetition of the typology. It's really, what is the extent of this issue? Is this a real issue? Is it an issue for us? Or is it an issue for the G7, G10, G20 countries? Does that make it clearer?
It helps. Thank you, Ms. Archer.
Okay, so that's the first thing you have to do. You need to find out what is the extent of this issue. What are the challenges that are facing the prosecutors and the law enforcement agencies and the FIU with regard to bringing matters to court with reference to beneficial ownership and the way in which these IBCs and their client have structured their business? How has it hindered the prosecutors? And then the second part is they want you to look at what are the difficulties associated with tracking ultimate beneficial owners. So now you talk about the extent of the issue, and the extent of the issue is supposed to ultimately tell you at the very end in that first evaluation where the issue is. What exactly is the core issue in this whole system of using these corporate vehicles to hide the human behind it? Then they ask you, they want you to tell them how you're going to track these ultimate beneficial ownership. How are you going to do it? And then lastly, they want to know the measures that can be used to assist with the problem. And whatever measures that you put in here, it has to fit in with the jurisdiction that you're talking about. It has to be something that the Bahamas is either talking about or interested in doing or has already done. And you could always tie it into another jurisdiction, because don't forget now, in the Bahamas, our clients come from all over the world. And so you could always bring in another jurisdiction and tie it into your answer. So this question is worth 50 points and you want to get at least 40. And that means it's a lot of work. Anybody else have questions?
I hear you keep saying IBB.
IBC, International Business Companies. Remember, I said a company can be incorporated under the Companies Act or under the International Business Companies Act.
Okay. All right.
Right. And the one they're talking about is International Business Companies.
Okay.
Yeah. Any other questions? Everybody's quiet.
I have a question.
Go ahead.
In terms of breaking down, like, our approach to the question, then in terms of looking more into IBCs, then you would say to look at the act itself as a start in terms of
No, you don't need the act itself. No, you don't need the act itself. IBC is just a company that is incorporated under that act. It's a company, a single entity. That's all that means.
Okay.
It's just that if you go to the registrar and use silent glass company and you want to know who owns it. So when you go to the registry, they give you the annual return. And when you look at names of shareholders, you see company 1, company 2. And that's what they're talking about. So who owns this company? If when I look on the shareholders, I see more companies. And then when I look up, I ask them, I'll say, okay, so this says shareholders of this company is company 1, company 2. Can I see the annual return for company 1, company 2? And then when they get it, they say, oh, company 1 is owned by a financial corporate service provider. And company 2 is also owned by a financial corporate service provider. So how am I going to know who owns this company?
Right.
So IBC and LLC is the same concept.
Yeah.
Okay. All right. Thank you.
If I may, the term LLC, can you tell me what it stands for?
That's a limited liability company.
Okay, thank you.
Okay, so a company, an incorporated company, has limited liability. That's one of the features of it. So normally people would compare a sole proprietorship versus a partnership versus a company. So when you have a sole proprietorship, all the liability is on that proprietor. His assets are not separate from his business. But when you have a company, the individual, the assets inside that company does not belong to that individual. It belongs to the company. And your liability is limited to the amount that you invest in the company. That's the shares that you purchase, the capital. So that's why I say liability is limited. It's limited to the extent of what you invested in the company.
Thank you so much.
Okay. Does everybody know what question 1 is about?
Yes, thank you very much.
Okay, so don't go on the deep end regurgitating with the FATF concealment of beneficial ownership. They're looking at really what's the challenge facing those persons. So even though we would have passed the Register of Beneficial Ownership Act, you need to find out now, how has that helped? Or what other measures other jurisdictions that are similar to ours have put in place? And whether or not the extent that we went is far enough compared to other jurisdictions. Okay, B, what's B about?
Well, I started off my well, not start off, but in my draft, I was looking at POCA and how they have the fines and then the jail time for not reporting if you have knowledge of someone committing a money laundering offense.
Okay.
I don't know if that's a good way to start it.
Well, they ask you to explain the consequences. To report. So how's your approach again?
So yeah, I just went, I looked, I know POCA, POCA, and then the transaction reporting act, I think. They talk about if a person knows or has suspicion of, if they don't report that, reported, and I guess it comes to like with the authorities, how they could face jail time and then the fines that they could face.
Okay.
That's as far as I got.
Yeah, because this is for 15 points. Mm. So what triggers the failure to report?
Could we discuss, I guess, the fear of reputational risk on the particular firm or financial institution? Business risk, operational risk, things of that nature.
Mm,
And if
You
it
can
goes to the extent
put that in
where
paragraph. Okay, go ahead.
sorry, Mrs. Otter.
Go ahead, Maria, speak.
Hi, perhaps we can start about, we need properly trained staff who knows, first of all, who know what to look for. For example, in banking, when opening accounts, your customer rules, the different deposit tiers and blah, blah, blah. I think we can start off with training of staff. The staff have to be properly trained and to know if there's a need to report, first of all. And then after you report, then of course your MLRO would have to be somebody, well, they should report directly to the board. And then at that point, like the lady was just saying, I don't know who that was. At that point, it may be a reputational risk, a legal risk, all of the other risks that we could discuss that may ultimately cause a company or a bank to knowingly not report because of these risks. So we could start off with, we could speak about training. Staff have to be properly trained to identify issues. And then also too, we can move on to the risks that firms may be afraid of due to firms may be afraid of why they may avoid. And of course, that would be definitely illegal. I don't know if there's something else that we could talk in the middle there in between training of staff and then the board and the MLRO knowing what's going on and still not reporting it. I don't know if there's something else we could stick in the middle there to put more meat in this.
Okay. Don't mix up V1 and V2.
Okay, all right. I was talking about both. Yeah, you're right.
Yeah, don't mix them up. So the consequences of failing to report, and then you can also add near to the end of that the consequences from the institution's point of view: loss of customers, loss of business, reputation risk, business risk. But when you get the part 2, describe and evaluate the key elements of an effective system. You spoke about staff training, but what else do you need for an effective system for suspicious activity reporting? There's more than just training.
Should be, I guess, a clear indication of who or how the employee should go about making the reports. I noticed in chapter 15 or 16, it talks about in some instances you may choose to go through a manager because, for example, a manager or senior manager may be privy to some things that, the typical employee doesn't know about in terms of saying, all right, well, this is truly something that's suspicious. So in those cases, the manager could be beneficial, or in some cases, other companies may choose to go directly to the MLRO. So I guess having a clear line of, who all is involved so that the report can be filed. That's another thing I think should be included in the second part.
Yeah. So they ask you to describe what is an effective system, like what should actually be in place, and they want you to evaluate it. And you evaluate it by giving them examples of cases that happen, either you are aware of it or actually happen on the job. That's what the evaluation comes in. So you would state what are the key that an effective system should have for reporting, but then they want you to evaluate it, which means how did the company, or how does it go about implementing it and making sure that it is effective? And you only could do that by giving examples of matters that actually have been written and sent either to the MLRO or written and sent to the head of the department for onward submission to the MLRO. That one you need cases, some examples. You get your points based on your examples. And if they tie in to your system for suspicious activity reporting, they have to be connected. If it's disjointed, then you're not going to get points on it.
Okay.
And C, that one should be easy. Analyze the role of the compliance function. Evaluate what measures can be taken to improve and develop the AML compliance culture within a firm. Anyone started that one?
No, it is that number.
This one is worth 20 points. This C ties in everything that you have learned over the whole duration of this course. So the first thing you start off with, it tells you to analyze the role. So when you're analyzing a role, what are they looking for?
I guess there are responsibilities
Yeah.
within your firm,
Mm-hmm.
which should include implementation and monitoring of their internal procedures and controls, I guess, to combat money laundering. So they should be advising the senior board the risk, money laundering risk, developing strategies to combat that. Risk management systems may also be effective. They should also be training the staff. Yeah, I haven't really expanded on this as yet, but.
So the thing about, talk about the role of the compliance function. They want to focus on the responsibilities and the duties that relate directly to protecting AML risk. So you're actually picking out the key functions that deal directly with protecting AML risk from a company perspective.
Okay.
And then they ask you to say what measures can be taken to improve and develop the compliance function within a firm. And so for that part, you should be able to give some examples. Maybe on different companies or different measures that your company put in place to create that culture. Because sometimes you can have as many training sessions as you want and you still don't have the culture. So they're looking for you to tell them or give them some inclination of how you can create that culture where people are always aware of money laundering risk. Okay, so let's go to chapter 15, transaction activity monitoring. Why are we required to monitor a client's transaction? Why is that a requirement?
Because it's a part of client due diligence monitoring. It's a statutory requirement and it allows you to see whether or not the parameters of the account have changed from when the client would have first opened the account and to detect any money laundering.
Shari, you finish or you drop off? Oh, okay.
Sorry, my mic was giving me a little bit of problems. And to detect any money laundering attempt.
Okay.
So it's basically just to determine whether or not there's any unusual transactions outside of what the account or the client would have stated how the account would behave in the beginning. So it's a detection. method.
Okay, I'm listening. What you need to formulate in your mind at this point, because you're at the end of this AML session now, and then you're going to move into the next session, this GRC. Whenever you think of any function or responsibility or duty in this role, you always have to be cognizant of why you're doing it. And the why you're doing it is because there is an international framework. So you go all the way back to chapter 1, 2, and 3. Because everything is coming together now when you start talking about transaction activity monitoring. Why are you doing this? Why are you monitoring? Why are you looking to see whether the parameters are still viable? Why is it that your client has changed their transaction? So it's a bunch of whys. But behind all of that why is that there is an international framework that embodies all of this. And your whys are answered when you go to your actual international source. So if you haven't at this point in time read all of the recommendations, then you need to read the recommendations. Because the FATF recommendation tells you why you are doing this and why it is so important that you are aware of changes that happen during a client's relationship. So you are right, Shari. Those are the points that you're looking for in terms of transaction and activity monitoring. But remember, the reason why you're doing it is because there's an international framework in place, and that's separate from our domestic framework that deals with transaction activity monitoring. Now, in most institutions, depending on size, and you notice whenever the central bank writes its guidance on AML, it's always that whatever policies and procedures or systems you put in place has to be based upon the size and the complexity of your business. So that means they leave it up to the institution itself to determine what it needs in order to meet its legal requirements. So in some institutions, you have an automated system that does everything. It tracks every activity. Who is going to, when it went there last, how much was sent. You have some that are actually manual because the institution is so small, and you have others that is a combination of both, automated and manual. Each one has its own faults, but you'll find out it's always based on the organization. And the key thing to anything to do with activity monitoring is CDD. Have to know your clients. And your customer due diligence has to be up to date. Now, when you talk about monitoring, what exactly do you monitor and how do you monitor it? What are you looking for? There's some key things you have to bear in mind when you're doing activity monitoring. What are those? Just off the top of your head, you should have an idea.
Well, when a
I
customer
would say
first
you,
opens there, sorry, go ahead.
no, you can go ahead, Talisa.
Someone's. Okay, when a customer first opens their account, they would basically indicate the amount that they expect to be transacted through their account. And
Right.
so throughout your monitoring, you're just checking to see whether their activity falls within the parameters of what they initially opened the account for, or the purpose of opening the account.
Mm-hmm.
So if it falls without,
No.
if it falls outside of the parameters, then that should kind of give you leeway to ask further questions and so on and so forth.
Okay. What I want the class to be cognizant of is whenever you're talking about, but it's different topics, but when you talk about transaction activity monitoring, I want you in your mind when you read the chapter, if you haven't read it yet, or if you read it again, separate domestic banking from international banking. Because it makes a difference. So if I were to go on the answer you just gave, you're talking from what angle? Domestic or international? It's a
Well,
sound.
I really didn't sever the two.
Uh-huh.
I guess so. It's just kind of a combination of the two. But
Yeah.
domestically, I would think that based on the risk of the person, so it's either low, medium, or high risk. So I think that really should fall within the parameters. So I guess on an international level, that could fluctuate.
Right. It's more dynamic on the international side. Because don't forget, now go back to question 1, they're using IBCs. That's their vehicle. And so they're doing business all around the world in different markets. So yes, when they first started, they may say, okay, I'm in the business of moving suitcases. That's what I sell as an intermediary. But over time, they get other opportunities. And so they use that companies for other deals, which would be outside the parameters of what they gave when they opened the account. Similarly, you could have the same thing here in a domestic company where someone has a license to do, I don't know, sell ice cream. They move from ice cream to selling sodas to frozen this and frozen that. So if you don't keep your customer due diligence up to date, then you're always going to be having trigger points that really do not evolve into an actual suspicious transaction or suspicious activities. So that is the key to knowing who your customer is and where they are operating and why they're operating where they are. Now, another thing that you have to remember when I say differentiate between the two, because depends on where you work or where you hope to work. If you're going to deal with international clients, your focus is also going to be not just on the parameters and making sure your customer due diligence is up to date and that you know your client, but you also have to look at sanctions list. And the sanctions list, I'm sure you all are aware now because Securities Commission and central banks send them out all the time of the listing of all the persons who are on the US list. And that list changes over time. So that's how you monitor your high-risk clients. And most companies in their automated system has a feature where the computer actually swipes every day, looking for names of those persons that are on the listing of sanctioned individuals. Then you also have to know your clients in terms of knowing where they do business, because there are sanctioned countries and you have to make sure that you do not violate those. Now, key to doing this transaction activity monitoring is you have to know what are the risks involved. So someone tell me, what are the risks involved?
You're talking about the risk for the transaction per se, or
Mm-hmm. So your
the risk
transaction
of
is
the
moving
go
funds.
ahead, sorry, Ms. Ahmed.
No, I
Uh-huh.
said the risk really moving funds. That's what this transaction activity monitoring is all about. Moving funds going in and out. So what are the risks?
I would say the risk for the financial institution, whether it's the commercial or offshore institution, the risk would be in moving illegitimate funds
Mm-hmm.
as well as just knowingly or unknowingly, and basically conducting business with somebody that has has been conducting a predicate offense or
Yeah,
involved in money laundering in some form. So you're just basically trying to figure out whether or not this person is there are any identified risk involved in the transaction. If you're funding, for instance, a terrorist activity,
mhm,
or if the person is just using your account to clean their money.
exactly. So when you think about transaction monitoring, you have to think about what is a more or less say an effective framework to do transaction monitoring. And remember, whenever you speak about AML, everything is risk-based. So your clients are already risk-based, but you also have to look at other things in terms of determining whether or not the client themselves exposes the company to more risk. And so it says under section 6 in chapter 15, it speaks about risk-based transaction monitoring. And it says that the framework will take the inherent risk of the products. So I think it was what, unit 4 or 5 that spoke about risk assessment in the same manual. So the risk-based framework looks at the products, the services, and the volume of transactions and takes that into account. So the company itself should know, based upon the products and the services that it offers its clients, what those are risk rated. And then you apply that to the actual customer themselves. And what you actually look at, because this is transaction monitoring, you're going to be looking at the volume of transactions that they either anticipated or they are actually doing now. So it's a combination of things in transaction monitoring. And then you look at, from your reading and your continuous reading in this field, you're going to look at methods that customers may try in order to carry out their money laundering efforts. So it says that the methodologies applied for the detection and management of unusual transactions that may relate to money laundering and terrorist financing will include 1, profiling, 2, the rules-based parameters, which we mentioned earlier, the accurate data capturing, and that's where the pod comes in and reviewing your monitoring system, the effective data filtering system, that making sure that the parameters are actually working, a defined methodology for detection, incorporation of watch lists where necessary. So if there are clients where you see things are happening outside of the norm, those are the ones that you put on your watch list to see if there are changes and why they are happening. Maintenance of good customer due diligence records. You have to make sure you have a good vendor system. That means that whatever company that you purchase the software from, they're able to give you updates on it. They're able to provide more services that you need based upon your clientele. The management of legacy issues. There are a lot of companies that still have legacy issues with regard to customer due diligence. And so you have to look to see whether or not the products and services that you offer now are compatible with what the clients and what you were offering before. You also have to see whether or not those clients are actually still in the business that they were in before, because some people used, at least in the international sector, they would use an account, open an account, but it's just used for savings. Like, I made one deal and that's it, and the money sits here. No transaction at all. Make sure there's a clear escalation process. provisions of contacts for escalation routes, and of course, regular reviews. So if you notice in chapter 15, they're referring to you a lots of different documents that you should read. And I encourage you to read those, especially from Wolfsburg. Wolfsburg is more geared towards the international bankers. And of course, the FATF typology is for any bank, whether domestic or international. So it says an effective transaction monitoring program will also include regular maintenance of the database system for operational resilience. And if you rely on your vendor for your system, you should ensure that they confirm that the vendor has the skills, the resources, and ability to provide the promised service and future support, maintain good working relationships with the vendor, agree a detailed system configuration when collaborating with third parties, conduct quality assurance and audit checks at regular intervals, and consider future standard product upgrades when deciding to use or when choosing a vendor. So for those of you all who are in AML, I'm sure you are aware that when the regulators come in, this is something that they check on to make sure that the monitoring program that you have in place and the system that you use meet these requirements. So they normally would ask for a copy of the contract between the bank and the vendor. They'd ask for a copy of the due diligence that was carried out on the vendor. They would also look at the configuration and it'll ask you how the parameters were set. When were they last reviewed? And they'll also look at the last audit report for quality assurance. And they'll also look at how the future upgrades will be made and whether the bank itself has a voice in how changes are to be made to the system. The other key thing that you have to remember about transaction monitoring is the escalation process. So it depends on where you work, that's domestic or international. What you need to do is do reading on what are the red flags based upon the type of business that the company carries out. Because the red flags can be used in staff training. And once you are aware of red flags, then the staff who are on the front line get a better idea of how things will work in terms of when they see a transaction and in their mind, they're thinking that it's suspicious or it is not suspicious. Nothing is better than giving an example that is real to the front line. So it says relevant staff must be trained on procedures for spotting and dealing with unusual transactional activity. And you must have a clear escalation routes. I know a lot of people like to give explanation of routes in words, but sometimes what is very good is if you actually do an actual diagram with the steps, with the numbers, and so it's clearer because everybody does not learn the same way. Clear escalation routes must be documented and easily available to senior management and employees. So you put it on the shared drive, so it's available for all staff. And then when you carry out your staff training, you give them out also to the participants. So the Wolfsburg principles suggest you generate alerts if unusual transactions are identified, tracking those alerts in order to ensure that they are appropriately managed within the institution, and that suspicious activity is reported to the authorities as required, maintaining an audit trail for inspection by the institution's audit function and by supervisors, and providing appropriate information statistics. So in large commercial institutions, you would see that there is one, maybe two persons who are actually designated just to deal with the escalation process and looking at alerts when they're generated by the system itself. So they would actually work those alerts and put their conclusion in the system. And then if those alerts warrant a UTR, you'll see a UTR being prepared. and then escalate it. And of course, the key to any transaction monitoring is, of course, reporting. And that's reporting to the board. So it says that a financial institution should ensure that they have adequate procedures or management information systems in place to provide relationship managers and the MLRO with timely information on customer transactions or activity. So in the role of compliance, you know, one of the essential reporting you have to do is to the board. And then you have to be cognizant of what information you provide to the board and that it is timely. And so included in your board report is always a section that deals with alerts. How many alerts were generated, how many alerts were cleared, and whether there were any issues with the alerts, which means that based upon the review and investigation, certain matters may have triggered the filing of STRs with the FIU. So it says there should be a clear allocation of responsibilities for reviewing, investigating, and reporting details of alerts generated by a system. Those responsible for this work should have appropriate levels of skills and be subject to effective operational control and quality assurance processes. So it's not just anybody who can actually work an alert. Normally, the position is held by someone who worked in frontline, who have a general knowledge of who the customers are, and they have a general knowledge on the activities that are carried out by these customers. And so they can actually make a sensible decision on whether transaction appears to be unusual or whether or not there is a suspicion. Any questions? No? Okay, so chapter 16 speaks about reporting. And that's one of your examination questions. Now we know in the Bahamas, there is a legal obligation to report. But what are you required to report? Because in other jurisdictions, they have the mandatory filing of the STRs or the SARs, and then they also have the currency transaction reporting. So what's required here in the Bahamas? Anybody? Is there a legal obligation for both in the Bahamas? Or just one? Hello? Annie? Are you there?
What was the third one, Miss? Well, the second one, Miss Archer, please.
No,
What was
I'm
the STRs, SARs, and the third one you mentioned.
okay. STR and SAR are roughly the same, not the same
Same.
thing. One is transaction, one is activity.
Right.
And currency transaction reporting. Is that a requirement here in the Bahamas?
I think
What is
so,
our-
because you have, I think when you buy money, you have to pay conversion fees and all of that. So I think so, right?
No, that's not what currency transaction is. Currency transaction is where there are limits on how much. So if, let me see, it's
Does that have to do
in,
something with the foreign
with the,
exchange? It's based on the limits of a particular currency?
no, it's the limit by the actual act. You don't know that? In
Well,
Canada,
You're talking about with reference to Bahamians transacting in another currency, like for example, US dollar.
okay, if US dollars, what's the limit? There's a dollar limit.
Is it
Well, I'm
the
not sure.
15,000?
How much?
15,000?
15,000 here in the Bahamas. Was it in the United States?
Is it 10?
10, yes. Canada?
I ain't sure with Canada.
No one that works in a Canadian bank? In class?
That's why I work at Scotia.
Okay, so what's the limit?
I know for all foreign currencies, well, other than the US, I think it's I want to say 100. No, I like 10. I ain't sure.
10.
I ain't sure.
It's 10.
10? Oh,
Mhm.
okay.
Okay. So where do we go to look for the limit for the Bahamas? What legislation?
Dollar limit. Is that the Financial Transaction Reporting Act or regulation?
Yes. The financial transaction
I don't,
regulation. Section 3.
there's a threat. Yes, there's also a threshold for detection and monitoring, I believe. For commercial banking, anything that's over 10,000 or 15,000 should be, there should be a red flag put in the system.
Yes.
And obviously for offshore banking, there are different thresholds. I know some offshore banks say if it's above 250,000, then it's
Depends.
monitored more closely, depending on what type of services the financial institution may provide.
Exactly. Everybody got that? I don't hear anything.
I know you also said we have to be cognizant of why. I was reading through earlier when you had mentioned client due diligence, and
Mhm.
in the commentary for FATF, I see here where they have, sorry,
Go ahead.
I see here where they have that when client due diligence is required, when a financial institution should be required to undertake CDD measures, is when it's establishing a business and then also carrying out occasional transactions above the applicable designated threshold. And they give an example of USD 15,000, including situations where the transaction is carried out in a single operation or in several operations that appear to be linked. That's the recommendation 10.
Mhm.
Commentary.
Right. So that's why I was telling you, by now you should know the recommendations and read all the commentary, because you're going to link it into your answers. So even though this is the end of this part, when you actually practice this in real life, those are your sources that you go back to that tells you why you're doing something, or give you more explanation as to what else do you need to put into this document to make it an actual viable document that senior management can actually use. So it's not just the transaction itself, but what exactly are you looking for? And what you're looking for, what you should include, comes from the recommendations. Okay, so in this chapter 16, it tells you the difference between STR and SAR. So they say STR is the transaction report and SAR is the activity report. So what's required in the Bahamas? What are we required to do? STR or SAR?
Both Jackson.
I heard a voice I have not heard. Was that who? Dimitri?
No, that's Omar. I'm answering the question that both are required in the Bahamas, correct?
It doesn't stipulate both, but I know from practice both, because not every, sometimes you cannot pick out a single transaction when you actually file your STR. Sometimes it's actually based on activities, the way in which the client is operating the account. So I would agree with you by saying both. But even though they're called STRs, there are instances where an MLRO would actually file an SAR, because the whole activity and the way in which the account is being operated is just not, leads one to believe that there is a suspicion of money laundering or some predicate crime is happening. So how do we avoid tipping off and breach of confidentiality?
I know one of the methods for tipping off that I'm aware of is that you continue the account's activity as normal unless otherwise prompted or given directive from the FIU. Because if you do not continue the activity as normal, then the client may become suspicious as to why you're not sending through their transaction.
That's one. Anybody else? Omar, you have any thoughts?
Not being in the field myself, I'm more of a theoretical person in this regard.
That's go ahead. That's all right. Go ahead. This is how you learn. Let's go.
Yeah, certainly. Say again. What was the question?
I was going to say you have a bank account. So think of it from that angle, since you don't have the experience. Breach of confidentiality and tipping off.
Okay. One of the ways I've learned is that, let's say there is a suspicious transaction report that is going to be, that's in the process of being filed.
Right.
And one of the representatives from the bank would have contacted the client and said the same, and just said that they told him, hey, you know, they're filing a suspicious transaction based on that last transaction.
Or they're linking into your account.
Oh, correct. Yeah. Yeah.
Right.
That would be the epitome of it.
Yes, that's tipping off. So how would you, as a frontline officer, avoid someone saying that it is a breach of confidentiality with filing their information with the FIU or the police? How do you get around that? How do you get around that?
A simple way would be that you try to like keep the group who are the employees that are aware of what's going on very small. Like you try not to involve more persons than absolutely necessary. And that way you could kind of eliminate the chances of the information being let out or leaked some way.
Not quite. Try again.
I have another suggestion, if possible.
Go ahead.
On a wider scale, you can implement a policy when you're similar to what she was saying, but on a wider scale, you can implement tipping off policies to make your staff aware of it being a penalty and a criminal offense to do so in the first instance. And then also probably if you're the relationship manager or the teller, whatever it is, the person who's in contact with the client, I would never make the transaction issue if the transaction hasn't gone through. I would never make it personal to the client. Probably say something like, well, our systems are having a bit of technical difficulty. We'll get back to you to resolve the issue. But never make the client feel as if there's something going on with that particular transaction that's personal to them.
Mhm. But what protection is there given for a staff member?
Well, the law says
disclose-
that you have immunity if you disclose. So the company won't be in trouble for disclosing, neither would the employee. So you have immunity under the act, the POCA Act, if you disclose it to the FIU. So it's just a matter of not alerting the client in any way to make them feel as if, or to give them a hint as to what's going on in the background.
Okay. So if I turn now to the section about mandatory reporting, and it asks the question, what is knowledge? So if we go to POCA, it says, a person commits an offense of money laundering if acting with knowledge or reasonable suspicion, he concealed the proceeds of the crime. So what does knowledge mean? How do you know that a person has knowledge?
Say the prelude to that, please, Ms. Archer.
Okay, so this is POCA, section 9. A person commits an offense of money laundering if acting with knowledge or reasonable suspicion, he conceals the proceeds of any crime. What does knowledge mean?
Meaning that it's confirmed, like there's no doubt. Yeah, that I guess they're actual facts to show that that person was involved in something.
Right, so it's an actual fact.
Yeah.
Okay, so what is suspicion?
Suspicion then would be, I guess, like how you were saying, if their CDD is outdated, so something may be flagged in your system. So it whatever comes up in your system, it doesn't match their typical patterns. So that of course makes you wonder that if this person is actually involved in something, but it can't be confirmed. It's just that whatever transaction took place is out of line with that typical transaction.
Yeah, this just means that a suspicion means that when you look at the transaction, it appears unusual,
Right.
but it's not suspicious. It appears that way.
Right.
But when you read section, which is 10, a person commits an offense of money laundering if he knows, suspects, or ought to reasonably have known or suspected that he entered or is entering into an arrangement. What does that mean? Reasonably have known or suspected.
Like if it was in the paper or something, it's like something that you should have known. It's something that's common knowledge.
No.
Ms. Archer, maybe maybe it has to do with the person's position, whether or not in your position, your capacity, for example, as an MLRO, you either know or you reasonably should have known that such and such a thing.
Okay, so what you're really looking at in that instance is in that section 10 and section 11 is you're looking at whether based on all the circumstances that person ought to have known.
Right, right.
Isn't there like a lot of shade of gray in that? Like
Yes,
that's
yeah.
so we're all guilty then. We'll never be innocent.
Well, okay then. That's true. Because at one of the sessions, the regulator had someone voice that opinion too. And they said that we'll always be in that situation where we ought to have known or we ought to reasonably have known. And the inspector said that goes with the job.
I guess what they're trying to say is if you have any suspicion, you should bring it to the attention of the responsible person, no matter if it may be true or not, and let that person then make a determination, the MLRO, as to whether or not it should be reported.
Exactly.
Don't take the responsibility on.
Right. So you're looking at it, and if you're on the front line and you say, okay, this client always makes this deposit. So today they made a different deposit. Then 3 weeks later, they're making a similar deposit. You don't think it is unusual, but it's outside of what they normally do. There's nothing wrong with that. I noticed the second time I report this money, what's happening? Say it in a casual manner. Then you watch the body language of the person. And you can tell whether the person has something to hide or they're just straight out say, guess what? I just got a contract for so-and-so and what I'm doing. And then you say, well, can you bring a copy so we put it on file? Because after several iterations of the same amount, the system will automatically begin to flag it because there's a pattern that's falling outside. But in terms of the customer due diligence, you would have already requested and hope to obtain on the next visit a copy of that contract. So this is when they talk to reasonable grounds to know or suspect. It's not just knowing whether the person is doing something suspicious based upon your training and your knowledge. You're supposed to be able to detect when things are not right. And based on the training that you gave to the front office, it should trigger something to them that they should file an unusual transaction to be escalated to the MLRO. So one document I find that is quite useful in terms of money laundering is the UK's JMLSG. It's in 3 parts. It is a lot, but you can use it as a guidance because it gives you a lot of explanation on how things should be done. Okay. Do you have, I don't know, your page might be different from mine, 2.4 in unit 16. There's an example of difficulties in making determination about suspicion. You have that?
What constitutes suspicious activity?
Yes, but I'm looking at the example. You have to say A is the MLRO of a private bank.
Yes, ma'am.
Okay. And A has been contacted by the police who wish to make an appointment to discuss Y Limited. Y Limited has been the subject of a recent review by an internal review team. Y Limited is beneficially owned by X and managed and controlled by a Jersey trust company. Following the phone call from the police, A examines the files in detail and discovers the following facts. X is the former French ambassador to an East African country. What does that tell you?
Person is a PEP.
Yes. Next, it is not clear when he retired. His brother is a member of the French Parliament. What is that telling you?
Two PEPs.
Yeah, and he's still a pep. Because they say they don't know.
PEP, always a PEP, right?
Okay. Not always a pep. It depends on what they're doing. Sometimes people get out of whatever it was they were into completely. Y Limited is a bearer share company incorporated in 1994. What I'm telling you. What's that point? What does that point tell you? Why?
That means the true owner of the company may be hard to determine because it owns bearer shares. Whoever would hold the
Uh-huh.
shares, they could stealing the ultimate beneficial owner probably.
Yeah, but still, what does that mean from AML perspective? Anybody? High risk. Because you don't know who's the owner. What's the next thing that same point triggers? Besides the bearer shares.
Ms. Archer, could you tell me what page the question you're reading is on?
553, Sherry.
Yeah, my page is a different page.
My page is 573.
Okay, thank you.
Okay, what's the second point on that same one?
Does it have something to do with the incorporation date, the 1994?
Yes, and what is it?
A lot of research to find out how many people these bearer shares were passed on to. I don't know.
Did they say that it's a particular type of company?
But bearer shares in most jurisdictions, they actually have been discontinued. So from 1994 to now, you shouldn't have any companies with bearer shares. So you already have a customer due diligence issue on that one. Okay, for some reason, the bearer shares are held by X, not by the trust companies. What's happening there? Anybody have anything to say on that one?
The bearer shares really don't exist.
In certain jurisdiction, it does. Few now.
I think only in Panama and a few others.
Yeah.
I'm just reading through the question because you were asking about the trust company. Why is beneficially owned by X?
No, for some reason, the bearer shares are held by X and not by the trust company.
Well,
What does that mean?
it means that they don't want the trust company in the affairs of the company, even though they're said to be managed and controlling it.
Mm-hmm.
Because and then trust companies are regulated. So if they own it, there may be more rules and stipulations in place.
Yeah, but it could also mean because they are bearer shares means that the owners have changed from the trust company to someone else. So Y Limited owns property in London as well as shares in a large publicly owned defense contractor that produces military equipment. What's that telling you?
Proliferation financing.
Of course. So in 1995, Y Limited entered into an agency agreement with a UK company for the procurement of contracts for the supply of electricity generators in East Africa. But that triggers. What happens in East Africa? That's the question supposed to come to your mind. What happens in East Africa? What is East Africa known for?
Is that where they have a lot of gangs and like revolutionary groups that kidnap people, commit some sort of terrorism?
Some sort of terrorism. Do they have such a thing?
No, it's terrorism.
I'm only asking, you know.
No, you're correct. It's either terrorism or it isn't. But I know East Africa is known for their violence and associated revolutionary African groups. Well, not African, but revolutionary groups that
Okay, so
are
what does that
using
trigger
guns
for you?
illegally. I'm not sure if this is considered proliferation financing, but they are supporting, not financially, but they are supporting acts of questionable groups in that area.
Okay.
For me, if I was a relationship manager, I would be wondering, well, what type of activity is going on in Africa? Why is Y entering in an agreement with this type of company? And then I would look at what type of business does Y do?
Mm-hmm.
How is it related?
Right. So for those who are just coming into compliance for the first time, in addition to everything that is in this manual, you have to know the world map. Because just how that is just general saying East Africa, you may say, okay, it's fine, but it's not. You have to look at the countries that comprise East Africa. So you're talking about Kenya, Uganda, Tanzania, Rwanda, you know, they always have in war, Burundi, and South Sudan. Those are the Eastern African countries. So now your mind's supposed to trigger as to supply of electricity generators in East Africa. So you know that's dealing with the government. So that's another high risk activity. And electricity generators, like she's saying, you could even put your suspicion that PMWD is taking place there. Proliferation of weapons of mass destruction. Then it says, it's not clear from the file how Y Limited had the necessary expertise to be able to discharge its obligations under the agency agreement, which means that he probably has an IBC. Based on his profile, when he opened the account, he has no knowledge of electricity generators, but then again, he could just be an intermediary. So an intermediary doesn't have to have the knowledge in order to get a contract. He's just moving the goods. So that could be a container with goods other than generators. In early 1996, large sums were paid to the contract account of Y, and these were accounted for as commissions. Now you see the red flag coming? Shortly thereafter, fund transfers from Y Limited were made to third-party accounts in Switzerland. You see the red flag again? And there is no obvious commercial rationale for X to own an offshore company. So would you file or not? And if you file, what would you say?
Shouldn't we find out some more information about what X is doing right now? He's the former French ambassador. They said it's not clear that he's retired or not.
Mhm.
We need some more information on him. What is he doing now?
You know what he's doing now?
No, I mean, does he hold a job? I mean, does he have, I mean,
Why do I need a job? Well, no. Why would I need a job if
I'm
I
not
have
saying he
the-
needs a job. Don't we need some more information on him, like where he's at now? I mean, he's just, and for me in this, he's just floating. I would ask some more information on him or try to find some more information on him.
Anybody else? I wouldn't ask him a single thing.
The first thing that's alarming to me is that the MLRO, who is A, has been contacted by the police. If the police are investigating him and we find out all this additional information, I think that's good enough grounds warranted to file a suspicious activity report, because you wouldn't want it to be where there is something happening and you turn a blind eye to it, saying that you didn't have enough or sufficient information. I think if the police came to the MLRO, that's suspicion in itself if he's under investigation. And given the fact that he is funding money and receiving commissions within filing, I would ask the client about how these commissions are related to the purpose of his account. However, I think once that information is obtained, I would file a SDR.
I would file too. I
authorities
wasn't saying I
aware.
wouldn't file, but I think we don't know any.
Yeah.
I think there's more information to be gotten in here too. I'm not saying take forever to get the information before you file, but I think you should still ask some more questions about him.
And then granted our systems that we have in place, I would probably do a world check, a Google search, something to accompany the SDR to see if there's anything that comes up. Or like she's suggesting, do investigations on the UK company to see what type of company that is that's providing the money and the commission. But I would still file. I would provide all this information that they've noted. I would provide it and say, these are my suspicions, that this is what we've been handed. This person is being investigated by the police, and we think you should just be aware of it.
Has some support to go along with it for filing.
Okay.
That's how I feel.
All right. So this example here is what they call a typical dilemma for an MLRO. So when you read these bullet points, as you know, as we get further down the list, some of these are red flags. So he has a company, and the company owns property in London. And then he also owns some shares in a defense contractor that produces military equipment. That's the first red flag. Then he entered an agreement with a UK company for contracts to supply electricity generators to East Africa. That's the second red flag. And you question, because you're saying in the bullet points that you're not sure where he got this expertise to enter into such a contract. And then you see large sums of money that are coming, saying that they are commissions. So the first thing is you go back to the contract to see what the contract said. What was he supposed to get? When whatever his service was, what was he supposed to get? Then your research then comes as whether or not the commissions received for the contract that he had, are they reasonable? And then once he got the commission, he sends the monies back out. Why? To a third-party bank account, not to the same name bank account, to someone else. That's another red flag. And then on top of that, the police have beginning to ask you questions about this account. So I would not go back to the client because either he himself or his company is under investigation, or the queries could have come from East Africa, a country out of East Africa. Or the questions could have actually come from the police in Switzerland, tracing the money backwards. But it's obvious from being a French ambassador to an East African country, he has connection. And he knows the region. It could be that all of this is legitimate. But on the other hand, a suspicion is raised because he was only an ambassador and now he's getting large sums of money and then he's transferring it to a third party. So it says near to the end, it says, it's never too late to report. In a situation, maybe that the police inquiry should be regarded as the final piece in the jigsaw. It allows him to formulate a suspicion and make a report. Remember that the offense of money laundering begins to be committed when knowledge or suspicion of criminality is formulated within the context of existing customer relationships. There is therefore a need for a defensive report to be made as soon as the suspicion crystallizes. The suspicion crystallizes when the police called. There is something not right here. The reasons that A is struggling to make a decision about his suspicions are largely irrelevant. The conduct of X and Y Limited should be the focus of A's deliberation. Every transaction a customer makes within the operation of an account or relationship has an interrelationship with other transactions and with other accounts or services for that customer. So when analyzed, transactions or instructions are capable of delivering a significant amount of information. The task of distinguishing a transaction that is suspicious from one that is unusual, abnormal, or requires further investigation comes with experience. And I put the little asterisk mark on that same last paragraph. And I put 4 lines under the word experience. And then it says the actions that will put the MLRO or even a relationship manager on inquiry will vary from case to case. What will turn an inquiry triggered by an unusual transaction into a suspicious transaction or activity report will be driven by a number of variables derived from historical activity, expectations, and comparators with the individual or generic profiles. The first step must be to determine the normal expected activity for that customer and then to move from curiosity to either comfort or concern. So always remember that. Look at the deliberations. And trying to determine when you're deliberating, what is the conduct? What are they actually doing? That's what leads you towards suspicion. And then it goes on to give you certain circumstances which might give rise to reasonable grounds for suspicions. The first one says, the transactions that have no apparent purpose or that make no obvious economic sense. Or the use of non-resident accounts, companies, or structures in circumstances where the customer's needs do not support such economic requirements. Now here they're talking again about the IBCs. Then it said the transaction being requested by the customer or the size or pattern of transaction is without reasonable explanation. A customer's own customers are not what would be expected for the business concerned. The transfers to and from high-risk jurisdictions without reasonable explanation, which are not consistent with the customer's declared foreign business dealings or interests. A series of transactions are structured so that each is just below a regulatory threshold. A customer who has entered into a business relationship for a single transaction or for only a very short period of time. Unnecessary routing of funds through third-party accounts and unusual investment transactions without an apparently discernible profitable motive. And you go in on this list, you can see these same examples given, which is demonstrated in this scenario that was provided by the examiners. So always remember that when you have a situation, you're looking at an account, you see transactions happening, you see they're moving to another jurisdiction, or when you're in that international arena, you see lots of contracts. You have to look at the conduct of what they're doing. The first 2 points, one stating that he was an ambassador in Eastern Africa, that's just pointing to you that he knows that market. The second one about he and his brother, and he is retired now, all that is gearing to whether or not the account should remain as a high-risk account or not. But what really determines whether this account is an account, one, that should remain as high risk, two, is whether or not he's in an activity that is considered high risk, bears to the fact that when he worked as a French ambassador, he worked in a high risk jurisdiction and he was a diplomat. So that's both. He had immunity then. So now he's going into doing business in a country that he's well known. So most likely his connection comes from him being an ambassador and he knows all the ministers. Knowing all the ministers means that there's room for corruption, because then he's sending money back to third-party bank accounts that are not his own in Switzerland. So where do Africans deposit their monies? Anybody? Where do Africans deposit their money? These are kind of questions and information you need to know when you're analyzing a scenario. Where do Africans deposit their monies? Any answers? No answers? In places like Switzerland. So these are all red flags. So always look at the conduct of the customer. And it says it's important to build into staff training a need for vigilance and for an intelligent assessment of the circumstances surrounding a transaction or instruction. So again, as a part of training, not just the annual training, but you could do monthly training, and where you can give based upon your clientele, you can give your frontline staff examples of things that happen around the world that relate to your clients in terms of knowing when there is a red flag, when suspicion should arise. Staff must be trained to apply the "does it make sense" test and not to take everything they see or hear at face value. Published sources of information will help us to indicate the kinds of situations that can arise. The FATF identifies new threats and researches money laundering and terrorist financing methods. The FATF typologies reports describe and explain their nature, thus increasingly global awareness and allowing for earlier detection. Most jurisdictions or regulators will also publish typologies or guidances on transactions that may trigger a suspicion. Any questions? No? Okay, so next in the chapter, they talk about designing an effective internal reporting system. And that's one of your exam questions. So it says the exact nature of the legal obligations to implement an internal reporting system differs between jurisdictions. So what's the requirement here in the Bahamas? Anybody knows? Of having an effective internal reporting system?
You're talking about with regard to the SARs and STRs?
Yes,
Well, I think an effective reporting system would be where you have a policy that outlines who's allowed to provide this information to the FIU within the system to streamline it so that you don't have a bunch of people just sending reports to the FIU. So you make it clear that it's the MLRO's responsibility to do so within the organization. And then you give a timeline to anyone who would have suspected anything or think that they suspected anything to escalate the situation. I know in some institutions, they give a timeline for if it's a line report employee to report it to their head of department or the MLRO directly. And then they give a timeline for the MLRO to report it into the FIU. So I think that's important because like we were discussing before, some people may believe that they may need a little bit more information in order to report. I know there was an instance I'm aware of in the past where someone took like 3 months to report and they didn't need all that time. So it's good to define a clear reporting line and also the time frame in which you're expected to report in order to give people a guideline.
Okay, so in your notes it says what? You also have to consider whether the reports will be verbal or in writing. Whether staff should be asked to put their names to the internal SARs. And whether supervisors or managers should be routinely asked to comment on an employee's internal SARs and whether the nominated officer should routinely acknowledge them. So in your experience, they're normally in writing, correct? There are some that are done verbally, but those are rare. Whether they should put their names, normally the internal policy requires them to put their name or their initials. They sign it at the bottom. and whether supervisors or managers should be routinely asked to comment on them. Normally, if it's coming through the system from the front office, you would have the managers or the supervisors comments on the transaction. And then whether or not they are routinely acknowledged, that depends on the internal policy. Because normally the UTRs, once they are compiled and they're put in a folder at the end of the month, then it automatically goes to compliance. So again, it depends on how the organization policy is structured. So how do you implement an effective internal reporting system? And sometimes staff are afraid to actually file unusual transaction. How do you get around that? Training again. And your training is focused on what?
Well, company policies, if you work for our company, this is our expectation. And then I guess, obviously a company's policies are largely derived from legislation and requirements.
Mm-hmm. But the key thing to having staff point out unusual or suspicious transactions is they have to be motivated. They have to want to do it.
You gotta motivate them to keep their job. They need to be
Well, whatever,
motivated.
but whatever way, you don't want it to come out like a threat, but that is the end result.
So the MLRO should be somebody who's approachable. You don't want to have fear in them, because chances are it's like, well, you know, I know that the MLRO won't be willing to hear me out, or, you know, it's always going to be some type of argument or backlash. So it's like, man, I'd rather avoid all of that. If I'm not going to be supported, and, you know, you may just choose not to file a report. So I think, you know, the MLRO should be somebody who is easy to talk to.
Yes, yes. Easy to talk to and knowledgeable about the subject.
Right.
Yeah.
Overall
That's it.
confidential,
And yes. You have to be-
confidentiality.
Yes.
Culture, because I think a lot of institutions, even outside of the AML and compliance thing, a lot of companies don't have an overall confidential, and this is what I have found over the years, even with senior members of staff. And when I say senior member, we're talking about AVPs and VPs. When you have very senior meetings at head office, by tomorrow, the staff.
You mean tonight? By
Yeah.
tonight.
Right. And I found that in the past, I've been in commercial banking, and by the night, we don't know what's going on in the meeting, and the meeting only had the senior people and perhaps one administrative person who was taking minutes.
Mm-hmm.
And it's really poor. So you lose respect among a lot of other things, and you lose respect for the place of employment. If you are a person of integrity yourself, you lose respect for them. And they don't have your buy-in anymore. So I think the tone is set to the top when it comes to confidentiality and everything else that leads up to staff feeling comfortable and confident that if they voice something, that it's, you know, it's not going to be used against them or cause them a lot of friction, you know, in the future.
So there goes your example for C in your assignment.
Oh yeah, I just spoke my answer. Okay. I gotta listen to this recording later then.
You just gave one example that you can use. So they say another feature of an effective internal reporting system is the requirement for employees to provide reasons for their suspicions. Now, you don't see that a lot. They normally just say, this looks suspicious. Some people give reasons, some don't. But standard written internal report forms completed by employees when making internal suspicion reports should always include a section requiring staff to outline the reasons why they have made a report. Now, I don't know if in your all experiences, you've seen these reports, that section actually filled out. And I've seen in the past, very few say why. They tell you it's suspicious, but not why. And so that means that the MLR has to do even more work, because if they don't know the customer, they have to really get to know the customer.
In my field, we write why because the MRLO will come and ask us why. So we do
Mhm.
write why. We
Yeah.
do just give a short, there's a place that say, like, I work in the casino. So we'll say, well, he bought in for so much money, but he didn't play. So if you sat to the table and you buy in, why aren't you playing? You walk away and you cash out the chip. So we would
Mhm.
give a reason.
Sound like that's washing money.
Mm-hmm.
That's what that sounds like. You have to watch the frequency of that
Yes,
person coming and doing the same
yes,
thing. Mm-hmm.
yes, yes.
Yeah. So it says inquiries by employees of customers. Whether employees should be encouraged to make discreet inquiries of customers about whom they have concerns before they report to the nominated officer is a common question that can only be answered with reference to the policy of particular financial services business. So it's making that same point that you just made. Whether or not you should go to the MLRO to say you see something that appears to be suspicious. And it says it depends on how your policy is written. It says we have seen that the formulation of a suspicion by an employee is very often a gradual process. It rarely happens instantly and is usually the culmination of an evaluation process that can involve inquiries of customers. Two things need to be borne in mind in deciding whether to encourage employees to make such inquiries. One, they must not be made once the employee has begun to suspect the customer. At this stage, employees must simply report their suspicions and not make the mistake of trying to substantiate them further. And two, they must not be made in such a way that the customer is alerted to the fact that the organization has concerns about potential money laundering activity, because this could result in tipping off. So it said employees should be encouraged to go through internal reports, should be encouraged to go through a form of evaluation of their own before making internal reports. Ideally, this process should avoid the requirement for employees to make excessive inquiries. It is the role of the nominated officer to undertake the substantive evaluation process. And then the chapter just goes on to talk about the evaluation process of the MLRO and the importance of having customer due diligence. Again, reference is made to exception reporting based on an automated system. And also the need for having the vendor support. And whenever you do world checks, you must make sure you do world checks on the searches by giving different variations of the name and make sure that you have captured all of the various responses that you should receive from just that name. And it says Interpol has published a very useful guide on this name, understanding naming in terms of transliteration. Because when you look at the UN, not the UN, the OFAC list of designated persons that are on their list, there's a very many variations of how persons from the Middle East names are spelled. And so you have to know all the variations of a name. And of course, you have to be able to review the actual software that you have and seeing whether or not it needs enhancements or it's not meeting your needs. So a nominated officer's evaluation record, which can be also in a standard form, should include the nature of the report received and the reasons for it, the details of the internal and external customer due diligence information that has been obtained and considered, the summaries of discussions with colleagues, details of any further information obtained from the reporting employee, the decision, and then the reasons for the decision. And of course, everybody knows that the template for filing an SDR is at the end of the act. Any questions? I know all the eager beavers are ready to go and start writing. Correct?
Yes.
Okay, all right. So next week, we'll go over the questions again. And if you have any questions in your research, make sure put examples in it. And so I would look forward to receiving your first draft during the week, so that when we meet again on Saturday, we can go through those, okay?
Can you leave your email, please? I don't know if you gave it already.
No, I didn't give it yet. I was waiting for the first person to ask me. But they all are so quiet. I'll send it with the link that Miguel sent for the class. Okay?
Okay, thank you.
Okay. So I'm getting there right now, so I'll send it to you in a couple. All right. So have a wonderful weekend. I hope I didn't bore you all too much.
Oh, this class is very informative.
Yes, thank you. I wish we would have had this class before the last paper.
Now listen,
Before the paper the other
Was
day,
the-
yes. That
I
was,
thought it, you said it.
yeah,
Wait,
that
but
this
hold
would have
on.
been fabulous with that risk rating, that client.
Yeah, because that's what we had to, what you're going into, I think. That was one of the questions on the last paper. Something to do with an,
The Mexican guy who
Yeah.
yeah.
because you had to
been
input all of
fabulous.
the steps, the consequences of taking on that type of client. What would you do as an institution if such and such happened?
oh, okay, I'm reading it now. Okay.
Yeah, this,
So you
Yeah.
had
this
to
would be,
include,
yeah, we should have had this class before that paper.
Ms. Archer need to teach the whole course. What
No,
happened?
no, don't try it. Don't try it. Have a great evening. Bye. Afternoon, anything you want to call it. No, but if you didn't do well on that question, you need to attempt it again, because that question is an everyday question.
No, the thing about it is ICA is a very emotional grading system. That's my 5 cents.
Why did that?
I just feel that I did very well on my first paper. My second paper I passed, but I did not do as well as I would have liked to do. And I could tell by the tone of my my review that it was a totally different personality that marked the paper. Also too, I've noted that I got a fabulous review on my first paper with only one notation, and I still have 70. My second paper, I wanted to meet that man in the parking lot, and that sounded like a man who marked my paper. And I find it as long as you know and you're writing and you're answering your questions in a knowledgeable way, then they pick on style and they pick on
Yes.
and then they pick on personal expectation. So it's
Mhm.
it's a personal expectation. It's yeah, and I so it's up in the air. It's not that somebody hasn't done well or does not know what they're talking about. It's the expectation of whoever that personality is that's marking your paper. And yeah, that's my 5 cents on ICA.
But they told you where you went wrong, right?
Yeah, where he thought I went wrong. I'm labeling this man, this person as a he. Yeah, where they thought, yeah, where they thought, because what I did, we had a 3-part question, but what I did an overview of risk rating. They did not want that.
No, no,
They don't
that's
want
what
to.
that's what I'm telling you now with this
Yeah.
with this one. Do not. I see the thing about it is when they pick up your paper to read it, and you're giving them back what's in the book, their mind is already gone.
Yeah, they
They
want
yeah.
to just jump on the question.
Yeah,
They
jump
don't-
on the question. Yes.
Yeah, they don't want. Yeah, so I'm annoyed with myself and ICA all at the same time. But that's
No, don't be
second paper.
annoyed with them. You have to learn the style of these
Yes.
examiners. They don't
Yes.
want that. And even if your paper is an A paper, then they go down looking for your spelling mistakes, your grammatical mistakes. They're gonna start taking off points.
Yeah, they well, I got a whole 30 points taken off my first paper for just one thing they said to me that I should have mentioned, the reputational or legal risk. In my first paper, I had one note, and one note separated me between 70 and 100. Well, I understand no one gets over 75 with them anyway, but
No.
I got one little note.
Mhm.
So yeah, they really difficult.
Yeah, but it's just all in learning. To me, it's all in learning. So that is why I told you all, be careful how you write this last one. It's not difficult, but they're gonna be really picky. Really picky. And they're gonna see if you're well read. I'm looking at your last assignment. What would
This
be your
paper is
mission?
more, I find this paper is more of personal knowledge too. I find this, as well as the last paper, relied a lot on personal knowledge.
Mm-hmm. Yeah, because you have to give examples. Okay. Yeah, this one wasn't bad. The second one. Yeah. I see that now. Notice the second one didn't really focus on transaction monitoring, Not really. It's more on the risk rating. But the same, your second assignment question is what happens every day in the AML division.
Yeah, no, I realized I fell down on, they didn't want to know that I knew what risk rating was and explaining blah, blah, blah. They just wanted me to hop on the question. So that was my
Right.
problem.
Mm-hmm.
Because
And
I
that's the
did,
same
yeah,
thing.
I did get, yeah, I
Go
did
ahead.
get it. Yeah, I did get the note that my paper was I did get the note that my paper was thoroughly researched and that I was knowledgeable, but they did not like that prelude at all.
Mm-hmm. Yeah. And another thing is that when you write your answers, that's why I say if you have the drafts and then I'll give comments on them in class, I wouldn't give you like, let's say you had some measures. I wouldn't say, and your measure A, B, C, D, E, F, G. No, because I don't want every student to know what someone else wrote. But generally I will go over the trends that I see. And when I make certain points, once you know your paper, you know if I'm talking to you or not. But it has to read a certain way. And if it's not written in that way, they're going to take points off.
Yeah, so it's not about just your knowledge or lack of knowledge. It's about style with them too.
Yeah, it's about style. It's about your assertiveness, your aggressiveness, all of that. They can actually read from your paper whether or not you have the acumen for this type of job. You can tell from the paper. So I think I've challenged you all enough, and I hope to hear my computer going bling, 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 bling. Which means that you all are sending me some papers. Okay? All right. So how many papers am I looking for? Hey, hold on, someone just jumped. 11? 11 papers. Okay,
I thought it
all
was
right.
like 20 of us.
I think it's a little, I think it's one more, couple more, one or two people on
Yeah,
it.
like 19 of us or something.
Oh, they just probably didn't, they're probably just gonna just listen to it. I'm trying to find Miguel's email. Okay, I found it. And let me do a reply all. All right, I'm sending it to you all. Worry not, worry not. Okay, and here it is. Okay, it's gone. You should have the email.
Okay, thank you.
Got it? Okay, you're welcome.
Thank you.
Okay, so what's my cutoff date for getting these now? Wednesday night? Thursday midday? It's your first draft. It's your first draft. I want to read it. See, I don't want you to go ahead until you're finished. And then I tell you, you need to start all over again. That's what I'm trying to avoid.
Well, I guess it'll be Friday.
And class on Saturday.
Friday morning.
You need time to review it.
It's a first draft. Jot down your thoughts.
Okay.
Okay, all right.
I need to see what direction you're taking it in. And I could always tell, because once I start reading your first paragraph, just like the examiner, it ain't not like you're going in the right direction. That's it. So I'd be just as ruthless as the examiners. So don't be discouraged. Don't be discouraged. I'll be trying to help you to get where you need to go. So it's not perfecting it now. You have enough time to perfect it. I want to see if you're actually answering the questions before you proceed to polish it up. Okay? So no
Okay.
Friday. No Friday, no Friday. Start cracking up now. How's that? You're all so quiet. It's not like you all are afraid to go and write this paper. Please write the paper.
All right.
Okay.
Okay,
Just
all
confirm
right.
a date.
I say what you saying Friday morning. Oh, you're trying to work me hard
No, I can do it Thursday. That's fine.
since you want Friday. Some people have already started, so they just need to send it to me.
Understood.
Yeah. But try before Friday. Because if I get all by Friday, you're talking about 20 papers, that's a lot.
Right.
Yeah. Okay. All right. So I'll hear from you all next week.
Right. Be safe.
Thank you.
Okay.
good
All
day.
right. Okay, you too.
Yes, ma'am. Good day.
Good day.